Welcome to the 18th episode in the first season of Justice Center Weekly, the videocast from the Justice Center for Constitutional Freedoms. I'm your host, Kevin Steele, and with me is the president and founder of the center, John Carpay. We're going to do a review of the Whatcott case in anticipation of a ruling being released shortly. This is similar to what we did with the Ingram decision, one show to review the case, and then a follow-up going through and commenting on the ruling. So, John, please introduce us to the case, and then we can get into the issues at play here.
All right. Well, thank you, Kevin. This is one of many, many Whatcott decisions. If you enter that name as a search query on the website of the Canadian Legal Information Institute, CanLII, you get all kinds of Whatcott cases. This man has been an activist for literally decades. He has had many successes as well as defeats in court. One of his successes quite some time ago was against the Licensed Practical Nursing Association of Saskatchewan. And he was a licensed practicing nurse in Saskatchewan, and he was doing peaceful expression of his pro-life and social conservative viewpoints on a public sidewalk outside of the headquarters of the Saskatchewan Licensed Practical Nurses Association. They took exception to that and tried to discipline him, and he was successful in pushing back. There's another Supreme Court of Canada decision with Whatcott as one of the parties, and that was in regards to socially conservative flyers that Whatcott had distributed in Saskatchewan, which the Saskatchewan Human Rights Tribunal took exception to and imposed a fine. And then Mr. Whatcott was successful at the Saskatchewan Court of Queen's Bench and then the Saskatchewan Court of Appeal. But then he, sadly, for the sake of free expression, he lost in the Supreme Court of Canada, which came out with a very muddled, confusing decision in Whatcott. More recently, he has been before the BC Human Rights Tribunal in regards to distributing pamphlets that question and challenge in a very provocative manner the transgender ideology. And so this man is a long-standing activist. Now, this case, this ruling that is coming out, is supposed to be coming out on Friday, August the 11th by the Ontario Court of Appeal. And this case is called R versus Whatcott.
2021.
The Court of Appeal decision is supposed to come out August the 11th, 2023. And I'm holding here this is the trial decision that is under appeal. So this trial decision dates to December of 2021. I'm going to go through so at this time, I don't know either the Ontario Court of Appeal is going to uphold this trial decision and affirm it, which would be good for free speech because it's a good trial decision, or the Ontario Court of Appeal is going to allow the Crown's appeal and overturn this and come out with what would be an incredibly threatening ruling for free speech, and I'll get into that in a minute. So let's start with the facts. This stems from the 2016 Toronto Gay Pride Parade, and Mr. Whatcott and some other self-described Christian Truth activists, they set up the Gay Zombie Cannabis Consumer Association. And so they had these, Mr. Whatcott and 5 associates, they marched in the 2016 Pride Parade in Toronto in July. They each wore green skin-tight outfits because they were dressed up as gay zombies. I always stress to people that these were not real zombies. They were people dressed up as zombies. So just so that there's no confusion. So Mr. Whatcott and 5 associates, they each wore green skin-tight outfits, which included masks that covered their faces. Each also wore some kind of rainbow accessory. Mr. Whatcott wore a rainbow-colored ballet tutu. Mr. Whatcott and his associates marched. They distributed flyers. The flyers, I'm reading from the judgment, so these are the findings of fact of the trial judge. The flyer consists of a single sheet with photographs and printing on both sides. The front of the flyer features a photograph of 2 men embracing with their shirts off. And then it says, gay zombies want you to practice safe sex. And then there's a photograph of a male anus with what are said to be anal warts. And there's an autopsy photograph showing a patient, a very gory photo with somebody with multiple lesions. And so these are the kind of flyers that Bill Whatcott often does. They'll have photographs of medical diseases, medical conditions. They'll have a photograph of somebody's mouth with a bunch of lesions or warts or this or that. He uses graphic photos. He's got one photograph of the Prime Minister Trudeau beside a photograph of a man's mouth purportedly depicting genital warts. And then flyer states, quote, Canada has embarked on a destructive journey towards sexual anarchy and homosexual-inspired oppression. The fruit of sexual anarchy is the rejection of God's plan of lifelong heterosexual matrimony and replacing the virtues of chastity, fidelity, unconditional love, and lifelong commitment to one spouse with promiscuity, polyamory, pornography, and homosexuality. The clear evidence contained in this package shows Canada's new sexual ethic is contrary to natural law. No good will come of it. The rejection of true marriage is also in direct opposition to God's law. It is our duty to warn you that those who choose to rebel against the God who created them do so at their eternal peril. For those reading this gospel package, we also want to let you know there is a God who loves you, who is real, and who has made a way for you to come to him. If you're tired of your sin and want to come to your Lord and Savior Jesus Christ and receive the free gift of eternal life, you can call. And then Mr. Whatcott gives his contact info. So this is the type of pamphlet. It's very hard-hitting. It's very in-your-face. It's very kind of a message that actually 40 or 50 years ago, 90% of Canadians, or more than 50% of Canadians would have agreed with. And so and these were packaged. They were handed out in what looked like a condom package, but if you open up the package, you got this flyer instead, or something to that effect. They also got their way into the Crown raised the point that they got approved. The gay zombies got approved as official participants in the Pride Parade, but they did this under false pretenses, of course, because once they got in there, they started to distribute literature which the Pride Committee would never have authorized. The legal questions that the court goes through is, did the flyers promote hatred? It's the first question. And then secondly, did Mr. Whatcott himself willfully promote hatred? It's a separate question. And then thirdly, do any of the defenses in the criminal code apply to the situation? So the judge rules against the Crown, and he upholds Bill Whatcott's free speech rights. And he says, I have reasonable doubt about whether the flyer promotes hatred for these reasons. First, the flyer has few, if any, of the hallmarks of hate speech. We might get into those. Secondly, the flyer is not sufficiently misleading so as to be inflammatory. And so the judge goes through and he looks at other cases where people were convicted of hate speech under Section 319 of the Criminal Code. So he mentions the Keekstra case. This is a teacher in a public school in Alberta, taught his pupils that Jews were treacherous, subversive, sadistic, money-loving, power-hungry, child killers, part of a worldwide Jewish conspiracy, so on and so forth. And he talks about other examples. In the Andrews case, it was a white supremacist newspaper published by the Nationalist Party, which described non-Aryans as inferior, violent, unclean, and a threat to white people. Nationalist Party claimed to be the only party capable of stopping the international communist Jewish conspiracy. The Jewish people used the Holocaust hoax to gain sympathy and power. And so he compares Whatcott to these different cases where there's convictions, right, for hate speech. And so the judge asked the question, would a reasonable person aware of the context and circumstances understand the flyer as exposing or tending to expose gay men to hatred, right? Because it is an offense, a criminal code offense, to willfully promote hatred against an identifiable group identifiable on the basis of race, religion, ethnicity, gender, sexual orientation, and now gender identity and gender expression have been added recently as well. So he requotes the paragraph here. Natural law is clear. So this is quoting from the Bill Whatcott's flyer. Natural law is clear. Homosexuality is incompatible with human nature. Disease, death, and confusion are the sad and sordid realities of the homosexual lifestyle. The gay zombies are concerned about the spiritual, psychological, and physical welfare of all potential homosexual pride attendees. So we want to give you this accurate information and encourage you to abstain from homosexuality, end quote. Now, the judge's analysis on this, he says, the paragraph is obviously offensive to many people. It does not, however, contain hallmarks of hate comparable to those one sees in the cases. This paragraph does not call for violence against gay men. The flyer does not suggest that society should segregate gay men because they are dangerous or a menace to others. While the flyer does suggest that the sexual practices of gay men are dangerous to each other, there is no suggestion that they threaten the rest of society. There is also no allegation of a plot or a secret cabal of gay men set on taking over Canadian society. Mr. Whatcott did refer to the, quote, homosexual agenda, end quote, in his police statement, but not in the flyer. It is very clear that Mr. Whatcott opposes the extension of legal rights to gay people. It is also clear that he decries the political culture that led Canada to extend legal rights to gay people. With the greatest of respect for those with the opposite view, that is something that Mr. Whatcott is within his rights to express. So, yep, there we go. Minority, social conservative viewpoint that I think, safely assume that most Canadians would agree or disagree strongly with Mr. Whatcott's outlook. But yeah, he's allowed to say that, he disagrees with what's happened in the last decade or two with the expansion of gay rights in Canada. Okay.
Well, he was also promoting this to the people there, so it wasn't like he was reaching out to people that weren't involved in the gay community. He was kind of targeting the gay community. So, I mean, to me, at least, that's not an attempt to vilify them. It's an attempt to persuade them, I suppose. That's just the way I saw that aspect of it.
Well, that leads me to another. I'm going to skip ahead just for a minute. That the judge says that Mr. Whatcott's not being very effective. He says, like, the people that he's giving these flyers to are the least likely to listen to him or be persuaded of anything. So I want to go briefly into some of the medical stuff, because what the Crown argued is that Mr. Whatcott's flyer is full of patently false, blatantly false medical information, and that also pushes it more in the direction of hate speech because it's saying things that are false.
Okay.
And by the way, the criminal code prohibition on hate speech has a defense of truth, by the way. Unlike human rights legislation, which does not give you a defense of truth if you get prosecuted provincially in a non-criminal setting. So there is a medical expert called by the Crown who is a Dr. Lautfy, and Dr. Lautfy is an infectious disease specialist with a master's degree in public health. Her specialty is clinical HIV research. She is certified as a specialist in infectious diseases and internal medicine, blah, 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 blah. Dr. Lautfy is I don't know if it's pronounced Lautfy or Lautfy. It's Loutfy. I'm going to say Lautfy. Dr. Lautfy is a highly qualified physician. Her expertise is impressive, and it is no exaggeration to call her brilliant. Defense counsel, Mr. Rosen, suggests that she is biased, and the judge agrees that there might be some bias in her research. Now, the judge concludes that many of the flyer's medical assertions were either in the ballpark of plausible or, at worst, an exaggeration. Some of them were untrue, but I don't know if we'll have time to go through all the details, but there's a lot of things that Whatcott put in his flyer that the trial judge says are true, or they're, a little bit off, a little bit exaggerated.
So he was extended the defense of truth, is what you're saying?
No, because the flyers were found to be not hateful in the first place. So there's no need to go further. But that would have been interesting if the judge had said, yeah, these flyers are hateful and Mr. Whatcott was willfully promoting hatred. Then the truth of at least part of the flyers, the truth about the medical conditions were could have been a defense. So Dr. Lautfi admits to a lot of things. That a lot of the medical stats about, death is the sordid reality of the gay lifestyle is simply wrong for the majority of men, but there are some of these sexual practices do shorten your life. An HIV plus individual starting antiretroviral therapy at age 20 could expect 43 years more of life, which is only 2/3 as long as individuals in the general population. So there, even with better treatment for HIV/AIDS, there's talk about the warts and lesions and different diseases, and that these diseases do exist amongst men who have sex with other men, but Mr. Whatcott's a bit off in his figures, but Dr. Lautfi admits that yes, there are these health risks, there are these diseases. Dr. Lautfi did comment that men who have sex with men are at high risk of anal cancer, and that HIV positive men who have sex with men are an even greater risk. Her own study noted that anal cancer is strongly linked to HPV infection, and that men who have sex with men are at a higher risk of contracting giardia. So all of that's in the trial judgment, and I think plays into the flyer would be more likely to have been found hateful if it was just bald-faced lie after lie after lie and things that were just patently untrue. And I think the point here of all this medical stuff is that the judge concludes that the flyers are not hateful, in part because the medical information in there is sometimes exaggerated and sometimes partially inaccurate, but there's a lot of truth to the assertions, the medical assertions. And then he says, I'm going to read a brief passage. The judge says, quote, "Moreover, it is not a crime to communicate something that is false or even a deliberate lie. Section 319 sub 2, so that's a criminal code prohibition on hate speech, obviously does not criminalize falsehoods. If it were otherwise, the jails would be full of journalists, politicians, cheating spouses, and possibly even some lawyers. It is only falsehoods that promote hatred that are criminalized." And I think that that's very important to understand, that the law punishes falsehoods in certain contexts. Defamation law, right, which is not criminal, would be an example, right? If somebody says something about you that you're dishonest and you cheat other people out of money, that's an attack on your character, which is part of your property. You can sue. So there are remedies available for certain kinds of falsehoods, but it's not a criminal offense to say something that is false. And as the judge puts it, it is only falsehoods that promote hatred that are criminalized.
Right. But of course, the Crown appealed this decision, and that's where we're at right now. Do you have any comment on their grounds for appeal or the defense? Maybe you could explain how the Justice Center became involved as well.
Yeah. So the Justice Center is providing legal representation to a group called Free to Care. Free to Care is a group of Christians. Well, there's probably lots of different people, but I guess the main part of the group is Christians who are same-sex attracted, right? So I guess gay Christians, you could say, or Christians with a same-sex attraction who strive to live a celibate life, who embrace the Christian teachings on marriage, who embrace the the Christian teaching that sex between a husband and a wife is the only sex that is good and right in the sight of God, and other sexual expressions not right. And so, and by the way, this is a teaching of Orthodox Judaism. It is, to my knowledge, a teaching of Islam and a teaching of other religions that sexual expression outside of the marriage of a man and a woman is sinful or is wrong. So there are religious people in Canada who are same-sex attracted and who fully embrace their religious the teachings of their religion about sexuality. Now, Free to Care intervened in this case because the Crown is making the argument that to criticize and condemn and attack and denounce sexual behavior, as Bill Whatcott does in his flyers, right? He says that gay sex is bad for you, it's bad for your health, and it's bad for your soul, for your salvation, right? So he's very critical of gay sex. The Crown's position in appealing this is that to come out with that kind of aggressive, vociferous criticism of gay sex is an attack on gay people, and it promotes hatred against gay people, or in particular, it's gay men, because as far as I know, Bill Whatcott's doesn't talk much about lesbians or two women having sex with each other and what negative health consequences there might be. He doesn't get into that. It's all about gay men. So Free to Care applied for and received intervener status in this case, and they argued before the Ontario Court of Appeal that to criticize gay sex as unhealthy or as sinful is not an attack on gay people and is not the promotion of hatred against gay people. And I think that's to me, that's just an obvious, if you believe in religious freedom and freedom of expression, there's any number of things you might be critical of if you're religious. If your religion says that it's a sin to eat pork because the pig is a filthy animal, you're going to be critical of people eating pork. I mean, does that mean you're promoting hatred against people who eat pork? I don't think so. But you're saying it's a sinful practice that God disapproves of eating pork. There's all kinds of religions teaching all kinds of things on all kinds of issues and topics. And it's very dangerous if a court is going to say that, that this amounts to the promotion of hatred.
Yeah, any sort of criticism of a religious practice any practice whatsoever becomes hatred, even if it's within the confines of their religion. I understand. Okay.
It's not even limited to religion. You could be a person who's you have a profound, strong, conscientious belief that it's wrong to kill an animal. Okay, and that's a passionate belief, and it might not be linked into any particular religion. So you vociferously criticize the killing animals for their fur. So you go to a store that sells fur coats and you peacefully pick it outside and you say, this is immoral, this is a grave injustice. You have killed innocent animals just to turn them into coats, and shame on you, and this is bad, it's wrong, whatever. Are you therefore going to be found guilty of promoting hatred against fur traders and fur sellers, right? Mm-hmm. That's scary. That criticism of a sexual behavior of whatever kind, if that gets just equated with hate speech, it puts a chilling effect on all debate in society.
Right. I was just looking at the factum, which is the argument of the Crown here in looking or laying out reasons for appeal, and there's one kind of interesting one here. I'm going to read the whole of it to you. This is number 3, and I'll read it all. Remarkably, the trial judge found this material does not amount to hatred within the meaning of Section 3192 of the Criminal Code. End quote. That's it. That's their argument. Remarkably, he didn't find it. So I don't know. That doesn't sound like much of an argument to me, but you can tell me, John, you're the lawyer.
I have not had a chance to look at the Crown's factum yet, but it's my understanding from the Factum of Free to Care that the Crown has raised this argument that vociferous, aggressive criticism of gay sex amounts to willful promotion of hatred against gay people. That's the argument that the Crown put forward before the Ontario Court of Appeal. And I think
I agree. That's there, but I see this sentence here as a separate thing, standalone paragraph as a reason.
So you're saying the Crown in its factum has not raised any argument to explain why?
Well, they do, but they don't raise it in this particular instance. They just say, remarkably, the judge found this material does not amount to hatred. Well, obviously.
But you're going to be posting the Crown's factum on the website,
oh, yeah.
right? Yeah,
all
okay.
of this. Yeah, don't worry.
Yeah, people can read through the reasons. So by the time this video cast is released, we may very well have had the release. Again, the Ontario Court of Appeal is expected to release its decision on Friday, August the 11th. I'm hopeful for the sake of free speech in Canada, for the sake of freedom generally. I'm hoping that the Ontario Court of Appeal will affirm this trial judgment that we've reviewed today. And I want to take this opportunity again to thank all the people that are supporting the Justice Centre financially with your donations. You make it possible for us to carry out this work in defense of the Free Society. So thank you very much. And please continue to donate so that we can put these arguments before the court and defend our fundamental charter freedoms of conscience, religion, expression, association, peaceful assembly, and so on.
Yes, and I will point out that all factums will be posted on our website, and you'll be able to see all the documents there. I think it's worth mentioning just before we close that, or reminding people that, free expression is not for necessarily expression that you agree with. It's sometimes, or a lot of the times, there to protect expression that you don't agree with. That's the stuff that is important to protect. And I think I'll leave the last word on that to you.
As Voltaire said, I disagree with what you say, but I will defend to the death your right to say it. The Supreme Court of Canada in the Zundel decision pointed out that majority opinion does not require constitutional protection. It is protected. It is tolerated in any event. So we don't have constitutional protections for majority opinion or majority religion or majority anything. It's all about protecting the rights of a minority to say what the majority might deem to be wrong or misguided or dangerous or false. And so that's where the Justice Centre is going to continue to fight for the right of each person to express their opinions in a peaceful manner. And it's one of the pillars of the Free Society. We absolutely need to cherish and hang on to our freedom of expression.
Great. Thanks, John. And I know we're going to look forward to going through the ruling once it's issued. Well, we're going to tear that apart. Anyways, great. I'm glad you could be here for this sort of preview of the ruling, and I hope to speak to you again real soon.
Talk to you soon, Kevin. Take care.